Good morning. If you want to be a very successful lawyer, if you want to claim that you know every root of our system of law applicable in India, and particularly Hindu law is most important law. All law graduates, undergraduates, students, those who are aspiring for elevation must know the basic principle of Hindu law. But apart from that, basic principle law, certain subjects plays very important role in a partition suit. So for that purpose, I share the judgment AR 2025 Supreme Court 495. AR 2025 Supreme Court 495. In the seat, if in this suit, if you go through the judgment, you can understand how trial court time to time seems to have framed issues, additional issues, again additional issues, so many things. So therefore, you go through all, and also the doctrine of related back. Doctrine of related back. Doctrine of relation back. That doctrine was discussed, and section 14 of Hindu Succession Act was discussed. The property of female widow became absolute property, and also Hindu Adoption and Maintenance Act section 12C. So all these clubbed together, the trial was there before the lower court. A adopted son of a widow filed a suit stating that his mother have no right to execute sale deed as well as gift deed to other defendants. And the trial court seems to have decreed the suit for this adopted son as considering him as a sole legal heir to succeed the widow defendant, one who subsequently died. But however, the sale deed executed in favor of other defendants was not set aside, but gift deed executed was declared as null and void. These things are there, therefore you have to go through the entirety of judgment. Facts of the case is much important, that a person seems to have married the adopted son's mother initially, and since there was no issue, subsequently married another lady with the consent of the first wife, and the children were born to them. This is what happened. And subsequently, after death of her husband, she seems to have adopted the plaintiff before the lower court and appellant before the Supreme Court as well. But High Court has set aside the judgment, setting aside the lower court judgment. But Supreme Court has categorically held that adopted son, being adopted son, is entitled to succeed the mother as a only legal heir. So therefore, you kindly, Magesh versus Sangram and others, AR 2025, Supreme Court 495, kindly follow. Best wishes.